Hello students of grade 10, my name is Ms. Niju Bamfield and welcome to another session of Office Administration. Today we will be continuing our discussion on the retention, use of documents in the guidelines of legal stipulations. Our objectives are to define stipulations and to describe the main legal stipulations governing the access to and retention of documents. In our previous class, we looked at the definition of stipulations, and I would like to recap that definition for you. It says, it is an agreement, usually on a procedural matter, between the attorneys of two sides in a legal action. Some stipulations are oral, but the courts often require that the stipulation be put in writing, signed, and filed with the court. I would also like to recap what are the use of stipulations. It is an agreement between attorneys, as was mentioned. During a civil lawsuit, criminal proceedings, or any other type of litigation, the opposing attorneys may come to an agreement about certain facts and issues. Such an agreement is called a stipulation. Courts look with favor on stipulations because they save time and simplify the matters that must be resolved. Stipulations may cover a variety of matters. Parties are permitted to make stipulations to discuss or to discontinue an action, to prescribe the issue to be tried, or to admit, exclude, or withdraw evidences. And those are the recap points I would like to focus on. Now let's dive into our final three legal stipulations concerning the retention and use of documents. These are breach of confidence, secrecy provision, and Freedom of Information Act. The regulations pertaining to breach of confidence. What is breach of confidence? Breach of confidence is a common law tort which allows individuals or businesses to go to civil court to protect secret or commercially sensitive information. The law aims to prevent people to whom the information has been divulged in confidence from using it to gain an unfair benefit or advantage. As seen in the image behind, the two parties indicated we should have asked for permission to use that cartoon. We know that for many businesses and or individuals, they venture to using cartoons or images without the required permission or given credentials to the owner of the image. And so breach of confidence tends to target individuals who would want to use such information for unfair benefit. Confidential information. For information to be shown to be confidential and to establish that a breach of confidence has occurred, it needs to be shown that 1. The information has the necessary quality of confidence. 2. It was imparted in a manner which impose an obligation of confidence. 3. There has been an unauthorized use of the information to the detriment of the owner. A breach of confidentiality can arise in a number of situations where the confidential information has been divulged to a third party to the detriment of the owner, including where the information involves trade secrets, government secrets, private personal information, and professional relationships. The quality of the information. For the information to be considered confidential, it must appear to have a confidential quality to it. A good indicator to whether information is confidential is whether it is labeled as such on the outside of a folder or if it contains a confidential watermark running through it. This, however, is by no means the sole reason which information will be held to be confidential. Other factors need be considered as well. In areas such as patents or the registering of designs, certain information becoming public knowledge prior to the patent or design being registered would have huge consequences for the application. In a case such as this, the information would be treated clearly as confidential due to the nature of the outcome of that information being released to the public domain. The patent laws covers as follows: ownership, exclusivity, rights, law, contract, application, property, plaint, granted, or permission. Those are the areas covered under the patent registration rights. Obligation of confidence. When secret information is dealt with in a commercial setting, it is usually the case that an obligation of confidence is enforced by an express contractual provision. These are called non-disclosure agreements and are a standard business practice across many different fields. If the obligation of confidence is not expressly provided, there will in certain cases be an implied duty of confidence. An example of where this would arise is in an employment setting, as employees are considered to owe an implied duty of confidence concerning trade secrets as such like to their employers. Unauthorized use of information. Information may be supplied to a third party so that parties can do a specific task. For example, personal information may be passed to an employee of a company so they can enter the data into the company's computer system. If they were to do just that, this would be authorized use of information. If the person was to use the information for any other purpose, such as disclosing it to others, that would constitute an unauthorized use of the information and they would be found guilty of breach of confidence. Now, how can we remedy breach of confidence? Remedies available for breach of confidence actions are as follows. The following remedies are available when a successful action for breach of confidence has been brought. 1. Damages. 2. Delivery up and destruction of infringing materials. 3. Account of profits. 4. Interim injunction. This is where the information has not yet been divulged, but it is likely that an unauthorized disclosure will occur. The court will make an order banning the disclosure of the information. Lawful disclosure. 3 situations where making disclosure of confidential information is lawful are: number 1, where the individual to whom the information relates has consented. Number 2, where disclosure is necessary to safeguard the individual or others, or is in the public interest. And 3, where there is a legal duty to do so, for example, a court order. Let us now turn our attention to the regulations pertaining to secrecy provision. Data Secrecy Act 1, Basic Provisions, Article 1. This act establishes the notion of classified and unclassified data, degrees of secrecy, the procedure of data classification and declassification, classified and unclassified data access, classified and unclassified data protection, and oversight over the implementation of this act. 2. This act applies to state authorities, local and regional self-government bodies, legal persons with public authority, and legal and natural persons that, in accordance with this act, gain access to or handle classified and unclassified data. Article 2 of the Official Gazette of 79/2007 states, particular notions within the meaning of this article shall have the following meaning. Data are documents or any written, copy, drawn, painted, printed, filmed, photographed, magnetic, optical, electronic, or any other type of data recording, insight, measure, procedure, object, verbal, announcement, or information that, considering its content, is significant for its owner in terms of trustworthiness and integrity. Classified data are documents that were within the stipulated procedure classified as such by the competent authority and for which the degree of secrecy has been determined, and data that were thus classified and delivered to one country by another country, international organization, or institution that the receiving country operates within. Unclassified data. Unclassified data are documents without the determined degree of secrecy that are used for official purposes, and data that were thus marked and delivered to the receiving country by another country, international organization, or institution that the receiving country operates with. Data classification. Data classification is the process of determining the degree of data secrecy regarding the security threat degree and area of values protected by this act. Data declassification. Data declassification is the process of determining the ceases or reasons for which the data were classified with the appropriate degree of secrecy, after which data shall become unclassified with restricted use only for official purposes. Certificate. A certificate is personnel security clearance that enables classified data access. Data owner. Data owner is the competent authority within whose scope of work the classified or unclassified data were created. Article 3 states, data shall not be classified in order to conceal crime, exceeding or abuse of authority, and other types of illegal proceedings within state authorities. Degrees of secrecy 2, Article 4. Classified data degrees of secrecy are as follows: top secret, confidential, secret, restricted. Those are the 4 categories of classified data degrees. Let us turn our attention now to the regulations pertaining to the Freedom of Information Act, an act to provide for setting out a practical regime of right to information for persons to secure access to information under the control of public authorities in order to promote transparency and accountability in the working of the government and public authorities, and for the appointment of the Commissioner of Information, enacted by the Parliament of Guyana. Part 1, the preliminary. This act may be cited as the Access to Information Act 2011 and shall come into force on the date the minister may, by order, appoint. In this act, Chapter 101, applicant means a person who has made a request in accordance with Section 16. Commissioner of Information means the person appointed by the President under Section 5. Confidential means a record that would cause damage or be prejudicial to national security if made publicly available. Designated officer means an officer within a public authority designated by the authority to perform such functions as may be determined by that authority. Disciplined force has the same meaning as in Article 154 of the Constitution. Disciplined force means any group of persons functioning whether wholly or partially as a naval, military, paramilitary, or air force. B, a police force. C, a prison service. Or D, a fire service. Document. According to Chapter 503, A has the same meaning as in Section 89A of the Evidence Act. Document includes 1. Books, maps, plans, graphs, drawings, and photographs. 2. Any disc, tape, soundtrack, or other device in which sound or other data, not being visual images, are embodied so as to be capable, with or without the aid of some other equipment, of being reproduced therefrom. 3. Any film, negative, tape, or other device in which one or more visual images are embodied so as to be capable, with or without the aid of some other equipment, of being reproduced therefrom. B. Documents include any copy of a record which can be produced from a machine-readable record under the control of a public authority, however generated, such copy being deemed to be a record under the control of the public authority. Part 3, number 8 and through number 26 are relevant for such readings. Publication in Official Gazette. Categories of documents to be available for inspection and purchases. 10. Statement of possession of certain documents to be published. 11. Person to apply to Commissioner of Information where published statement does not specify a document or categories of documents. 12. Right of access to information. 13. Classification of official documents and accessibility to certain records. 14. Accessible records and information. 15. Documents otherwise available. 16. Procedure to make requests. 17. Duty to assist applicant. 18. Time limit for determining requests. 19. Giving access and deletion of exempt information. 20. Form of access to document in printed form or otherwise. Part 4. Rights of access to information. 21. Fees. 22. Deferral of requests to access public information. 23, procedure where applicant is not entitled to document as requested. 24, decision in respect of requests may be made on behalf of public authority. 25, requests may be refused in certain cases. And 26, grounds for refusal to grant access to information. The listings are available in the Constitutional Act for the right to access information. Part 5, exemption documents or exempted documents. 27, cabinet documents. 28, documents exempted if containing information likely to be prejudicial to defense of state, etc. 29, international regulation documents. 30, internal working documents. 31, law enforcement documents. 32, documents affecting legal proceedings or subject to legal professional privilege. 33, documents affecting personal privacy. 34, documents relating to trade secrets. 35, documents containing material obtained in confidence. 36, documents affecting the economy, commercial affairs, and certain documents concerning operations of a public authority. 37, documents to which secrecy provisions apply. And 38, disclosure of exempt document in the public interest. So we have come to the end of our lesson on legal stipulations concerning the retention and use of documents. I want to thank you for paying attention. My name is Ms. Neja Bamfield, and I was happy to be your tutor for this session. At the end of this session, you'll find a practical exercise which require for you to complete in your notebooks. The questions are, number 1, what role does document management stipulations play in the effective and efficient use of documents for decision making? Number 2, define the term regulation in your own words. What are the positive and negative effects of government regulations on information management and retention? Thank you once again for having me. I was happy to be here.